Today, we're going to be celebrating Women's History Month with a special edition of Lunch with Liz, where we are going to talk about women-specific estate planning. So I often get asked, well, why do you do Lunch with Liz? And we're coming up on our third anniversary next month in April. I started it because I just saw a lot of misinformation out there when it came to wills and trusts and deeds and joint ownership. And I just thought, well, wouldn't it be great if we had a place where every month I could just have a conversation with people about the importance of estate planning? They could ask questions, get clarification, and so that maybe person by person, I could help dispel some of the inaccurate information that's out there regarding estate planning. I see it all the time on social media, and a lot of it I just scroll on by. But this is my one time a month where I try to do what I can to dispel some of those myths. But I don't want you to walk away or start the whole conversation today confused, because estate planning is important regardless of your gender, regardless of your level of wealth, regardless of your marital status, regardless of your sexual orientation, and regardless of your age if you are an adult. So I'm not saying it's more important for women, but I am saying that we have unique circumstances that make it important to address estate planning. So I'm going to talk about some of those important aspects of why it's important to do estate planning. And then later, I'll talk about some of the important documents that I think your estate plan should hold. So the way today will work is I'll talk. You know, lawyers like to talk, right? So I'll do some talking. You feel free, raise your hand, throw a question in the chat as we go, or I promise I'm going to open it up at the end to take questions. But if you have something, you're confused about something, I will stop and we'll zig, we'll zag. My most important thing is you came on today, you're spending your lunch hour with me because you had some questions or you wanted some information. So I don't want you to go away today without getting that information. So if I'm not addressing something that you feel like you needed to know today, then let me know. Again, either in the chat, raise your hand. I don't need you to come off video if you're shy about that. Keep in mind, we are recording this because we do share it on our social media and our webpage for people that can't attend. So if you are shy, you can stay off camera, or you can just throw your question in the chat. My trusty assistant, Vicky, is here. So she'll be monitoring that chat for me. So if I missed your question, don't worry. She will make sure that I pay attention to it at some point during our programming today. I see some familiar names and faces out there. So welcome back to Lunch with Liz if you've been on here before, or welcome to Lunch with Liz if all my social media pleas for you to attend finally motivated you to sign up this month. So let's get started. Again, there's a handout in the chat. Vicki, you might need to add that again for the people that have signed in later. Again, that is just a takeaway for you. I'm not going to walk you through it, but it is a great way for you to share this information with other women in your life. So, why is estate planning important for women? Well, one reason is, statistically speaking, we live longer than men. I think right now the Social Security Administration, the mortality tables have us living on average about 5 years longer. Obviously, your hereditary and your life choices are going to impact that, but on average, women live about 5 years longer. So you have to plan for more contingencies, right? If your spouse is going to die before you, parents die before you have to have more contingencies as to your successor agents, your successor executor, who's going to make your financial decisions, who's going to make your healthcare decisions when your spouse or partner is gone. Because of that, women's estate plans are more likely to control. And speaking of heterosexual relationships here, of course, but for a typical male and female who are married, the male typically, statistically, will pass first, meaning that the female's estate plan is going to control what happens to that family's assets. Again, why it's important for women to do their estate planning. Because the woman statistically lives longer than the man, we more likely have to figure out what we're going to do about long-term care. I see it in my practice all the time where the woman is the caregiver for her husband, husband dies. Now woman has no plan for her long-term care. So when you're speaking with your estate planning attorney, if they are a good one and they're looking at your holistic picture, they're going to talk to you about what your plan is for long-term care and try to help you solve for that likely problem. Statistically, the vast majority of us will need some sort of long-term care, whether it's in the home or in a facility. Another aspect to living longer is having the money, right? Having the income with which to carry on after our spouse passes. Understanding how to pay the bills. What are the bills? Is it another important aspect of why estate planning for women is so vital. Another reason, and this is, I didn't realize this statistic until Vicki pointed it out to me, but by 2030, so a short 5 years from now, women will control almost 70% of all the wealth. And that's a great thing, but we need to have a plan in place for how we're going to be distributing that wealth. And if we have wealth, and by wealth, that doesn't mean $1 billion or $1 million. Wealth is very subjective. You know, everything I have is my wealth, and it may be very paltry compared to somebody else's wealth, but it's still everything that I have, and I want to care for it and make sure that my wishes are followed. So because we're going to control almost 70% of the wealth, we want to know how we're going to control it through our estate plan. Another reason estate planning is so important for women is we're typically the custodial parent if we have minor children. We are typically the main caretaker if we have minor children, and we're typically, again, I know there are exceptions to everything, but we are typically caretakers for aging parents. So we need to have a plan in place in case something happens to us if we hold these roles as custodial parent or a caretaker for an aging parent. And many of us in this room right now are business owners. So it's important to have an estate plan that includes the business in that estate plan so that we have a succession plan and or we have a mechanism in place that would enable whoever we have directed to have access to our business, have access to our business accounts, have access to be able to pay employees, for example, without going through the probate process. And then finally, the last reason I'm going to hit on about why estate planning is important for women is, statistically speaking, women will remarry after marriage ends in divorce or due to the death of the prior spouse. So planning how the person's wealth will be distributed between the original family and the newly married family is important. So that just gives you some highlights about why it is important for women. Again, it's not more important necessarily, but it is important that we address these things. So I have used the term estate planning probably, if you've counted today, probably I've already said it 50 times. So what am I talking about when I talk about estate planning? It sounds grandiose, doesn't it? Like, oh, my estate, like some Southern, antebellum mansion and 500 acres. But your estate is just all your stuff, however big, however small that is. And when we're planning for it, it's really an umbrella concept that takes into account wills, trusts, powers of attorney for finances, which lets someone make financial decisions for you, all your medical directives, so your living will, your healthcare surrogate, so that someone can make medical decisions for you and you can make predetermined decisions about how you'll have medical care as you age, your deeds for any real estate that you have, all your beneficiary designations. So think beneficiaries on life insurance, on 401ks, on IRAs, on annuities, pay on death and transfer on death designations on bank accounts and brokerage accounts, joint ownership of properties and of accounts, how you're going to take care of minor children, and last but certainly not least, how are you going to take care of any fur babies that you might have in the event of your passing? All of that for a holistic estate planner, we're going to be talking about, as well as what's your plan for long-term care? How how is it that you're going to pay if you need to bring someone into the home, go into an assisted living facility, or go into a nursing home? When I'm dealing with a client, my focus is what is the least complicated, most cost-effective way to accomplish the goal. And typically, I have a baseline of recommendations when it comes to that. One is a will, a last will and testament. What this document does is it transfers assets at death that have no other mechanism to be transferred. All right, Liz, that was a bunch of lawyer mumbo jumbo. What do you mean by that? There are a plethora of ways that things you own will go to somebody else at your death. If you have an IRA, a 401k, life insurance policy, for example, all of those have beneficiary forms. And if you have any homework to take away from me today, it's double check your beneficiary forms. Double check that they have the beneficiaries that you want, and make sure the form is still on file. I have a lot of cases where we had to probate an estate because a beneficiary form got lost. So beneficiaries are one way that you transfer assets outside of the will. The will has no control over beneficiaries unless the beneficiary form is lost. Um, Other ways would be joint ownership. So if you have a joint account with a child or a spouse, that's going to pass with the survivor of you without the will, without probate at all. And there are other ways that assets can pass without the will, outside of the will. So the only thing the will would control are assets that you haven't found some other way for it to avoid the probate process. So when I'm talking to clients, my total focus is typically how can we avoid probate with having these simple forms? So just a will, a power of attorney, and the medical directives. And oftentimes that comes into play with beneficiaries, with pay on death designations on checking accounts, with transfer on death designations on brokerage accounts. But sometimes we have to get complicated and we have to do something more expensive because the goals that the client has in mind requires it. And in that case, we would recommend that you have a trust. And I like to think of a trust like a bucket. And I know those of you who have been on here before, you know, that's my typical analogy is instead of Liz Moneymaker owning her condo, she creates a bucket. And in the bucket goes the condo, all her assets, so that when Liz Moneymaker dies, the condo or the bucket lives on. And I've named Tracy Mayo, for example, as the boss of the bucket when I die. And then it's her job to distribute all of that. And that's outside of the probate process. So I've probably gotten a little bit more in the weeds than I intended to for this particular lunch with Liz on those estate planning tools, the difference between a will and a trust. I do a whole hour on that on another lunch with Liz. But suffice it to say that when you go talk to your estate planning attorney, they're going to be talking to you about your options, wills versus the trust, or other ways to transfer your assets when you die. And a good one is going to look at all of them holistically and try to find the most economical, least complicated way to accomplish your goal. So I always say that's one part about estate planning is what happens to my stuff when I die. And that's where the will comes in, the trust comes in, and all the beneficiaries come in. But in my practice and what I've seen over the course of my career, the most important part about estate planning is your incapacity planning. So your powers of attorney and your medical directives. So the first document there is your durable power of attorney for finances. This document lets someone pay your bills, run your business, sell your house if they need to sell your house, if you no longer have the mental capacity to do so. So think, horrible car accident, stroke, Alzheimer's, other age infirmities. This document lets someone else act in your shoes. And the reason why it's so important is because if you don't have it and you haven't put it in place before you lack mental capacity, your loved ones or the government will have to step in and create a guardianship for you. And what that means is they go to court and a judge names somebody in control of all of your assets. And it might not be someone that you want. It could be a professional that you've never met. It could be a family member that you haven't talked to in 30 years, a family member that you don't even like. So having that durable power of attorney for finances in place where you have selected those trusted agents is very important. And if you were here when we first started, and I talked about how on average women live longer than men, it's even more vital that as women, we have a layer of succession in those power of attorney documents. So, for example, your primary could be your spouse or partner or child. And then you would want a secondary and a third so that you're, if you lived, till you're 90 something years old, we have already put in all those contingencies for these backup agents. And believe me, it happens. It happens where somebody drafts their power of attorney when they're in their early to mid 60s and it's still valid when they're in their 90s. So the more proactive and the more forethought we can give into naming those backup agents, the better. Same thing goes for your medical directives. So that's really kind of three documents in one. One part of that is a HIPAA waiver, all that privacy about your medical records. But the other two important parts are your living will, and that's where you get to say, what happens? Do you want the plug pulled or not? What type of medical care do you want if two doctors have determined you don't have a probability of survival? That's the living will aspect. And then the healthcare surrogate aspect is you naming someone to make medical decisions for you. Same concept as the power of attorney. We want to layer in 2 to 3 lines of succession for you as you age so that if your primary dies before you or your primary has some issue like a stroke or something, we have 2 to 3 more tiers that we can go to as you age. At the average life expectancy of a woman right now is 84. So we want to plan at least through 84 to make sure that if you become incapacitated, we already have those lines of succession in place. Does that all make sense? So we talked about why estate planning is important for women. And then I kind of hit on what I consider the three most important documents: a will, a power of attorney for finances, and your medical directives. And then I hit on a little bit about a trust, but again, that's a little bit more complex than I want to do in this lunch with Liz. With the caveat, if you have questions about it, I'm happy to answer, but I don't want to go into a 30-minute talk about what trusts are and how to use trusts. Just in general, trusts typically are used when you want to control from the grave, either for good or for bad. And that could be because you have minor children, you have special needs children, you have a blended family. There's a couple other really main reasons why a trust is better than a will-based plan. But if we can get you where you want to go with a will-based plan, that's typically my primary recommendation is that you keep things as simple as possible. Um, with that, I'm going to open it up for questions and I can go in deeper into any of these topics we've already talked about if you want me to flesh anything out more. Any questions?
I
Don't
have a
see.
question.
Yeah.
Hey, this is Sherry. Hey, Liz.
Hey, Sherry.
Hey. Yeah, if you own property, real estate that is paid for, clear, uh, would that go into your will or your trust?
It could go a myriad of ways. So let me give you an example. I will answer that question as thoroughly as I can. So when I see typical clients, they have a home or a condo, they have retirement, so IRAs or annuities or 401ks, things like that. Those are the two main sources of wealth that they have. They have bank accounts and all that kind of stuff. But for the 401ks and the IRAs, we know those have beneficiaries on them. So they're going to pass outside of the probate process. For their checking and savings, they can put pay on death designations on those accounts. So those will pass outside of probate. So generally, then we're just left with their house or their condo. How are we going to deal with that? How are we going to transfer that asset to their children or to another family member or a friend or whatever? So you have three options in Florida. One, you can do it via the will. So in the will, you can simply say that my home now goes to Liz. If you pass your home via the will, do you remember what I said like 5 minutes ago? That's a probate process. A will gets probated. A will does not avoid probate. So if you're using the will as that mechanism, that's going to require a probate. So that gives you two other options then. We talked a little bit about trust and creating that bucket. We can deed the house into the bucket once we've created the trust, and that would then say, hey, I want my house to go to Liz, and it would go via the trust, via the bucket, avoiding probate and transfer to me via your successor trustee. That's option two. Option three, which I have not talked about at all today, in Florida is called a ladybird deed, also called an enhanced life estate deed. That's a deed that replaces your current deed where we put a beneficiary on the deed so that when you die, the home automatically passes to the person you've put on the deed. There are pros and cons to the deed. I always, will flesh those out with anyone who's interested in them. But it is a great tool to avoid probate if you don't want to go to a more complicated estate plan like a trust. So those are your three options about how you would pass a home. Your other fourth option is to not do anything. If you don't have an estate plan at all, then the state of Florida has one for you. And it's a one size fits all. And it pretty much goes like this. And again, this is if you don't have a plan in place. If you're married, generally would go to your spouse. If you're not married but have adult children, go to your children. If not married, no children would go to parents. If not married, no children, no parents would go to siblings and then trickle out like that. There's some exceptions to that rule, but that's the general nature of the Florida concept that would be put in place if you didn't have a plan. Did that answer your question, Sherry?
Yeah, thank you very much.
You're welcome. Good to see you.
You too.
Yeah. Lon, did you have a question? You raised your hand, so maybe that was just to say hi. Hi. So, don't be shy. Again, you can use the chat if you want. My main thing is you came on here for a reason, so I want to make sure that your question is answered or your concern is addressed. So if you just want to throw out a topic or you want me to dive deeper into anything I've just talked about, I'm happy to do that. All right, we got a question. Did I hear something about Florida? If you are married and minor children, doesn't 50% go to spouse and 50% go to minor children? That's remember when I said there's some caveats about the plan. So it depends on whether those minor children are of that relationship. So let's say I have a relationship with somebody and I have two kids from a former relationship. If I don't have a plan in place and I die, then, well, I should say a marriage. If I die, then yeah, 50% to 50%. If those minor children are of that marriage, so the biological children of both of us, then it would go to the spouse. So that's the exception. One other thing that catches people crazy, I'll just hit this before I go to Heather's question, is if I own my homestead and I have adult children out there, not of my current relationship. So I own the home. My spouse does not own the home. I die without a plan in place, then my spouse doesn't own the home. The spouse gets a life estate in the home. The actual owners of the home are my adult children from that prior relationship. That that kicks people in the butt sometimes. So just like to throw that out there. If you know anyone that only one person's name is on the deed, we need to address that through an estate plan. And yay, I'm getting some questions. All right. If you formed a trust with the help of an attorney, should you be concerned if that attorney is a solo practitioner? That is, what if they pass away before I do? Well, Heather, that would depend on what was the attorney's role in the trust. If I just create a trust for you, so I've written out the trust and the terms that you wanted, and you've signed it appropriately, and it's witnessed, and I'm not a player anymore, then it doesn't matter if I pass away or retire or move to Portugal. None of that matters because you've named other people in the trust to take care of your bucket when you die or when you become incapacitated. If your attorney is in the documents, for example, if you've named him or her as the boss of the bucket when you pass away or you become incapacitated, then yeah, I would that would be a concern to me if you didn't have backup people for that person. But if all they did was write it, then it shouldn't be an issue. I I what we call administer trusts. So I take trusts other attorneys have written and follow their directives all the time. So as long as it's clearly written, you shouldn't have any problem. Next question. And if that didn't answer, Heather, just let me know. Next question. Would a business succession plan go into a personal estate plan, or does the business make its own succession plan? Yes. uh, what you want is you want to have the two plans work together. And the business succession plan is going to depend on what type of entity that you have. Do you have a corporation? In which case, your shareholder agreement is going to dictate. Do you have an LLC where your operating agreement is going to dictate? Generally speaking, if you have a business, generally now, we're going to steer you more to the trust option so that we can avoid probate that way. It's not always the case. I don't always have to go that route, but the vast majority of business owners, we're going to steer to a trust-based plan so that you can avoid probate, not have any stops in paying of employees or business operations if one of the business owners becomes incapacitated or dies. So I know that was a kind of a it depends answer to your question in a way, but they're two different plans that work together, if that makes sense.
Liz, would the business have its own trust then? Or would
So,
that be like my personal, the trust I make for my family more so with the business in it? Or I guess I wouldn't want a business in a trust.
right, we wouldn't have the business in the trust, but the
Okay.
trust would be able to control the business in the event you became incapacitated or died. And that's the
Oh,
way that you could avoid probate. That's what I mean. Like you want your business plan and your personal plan to mesh.
okay. So like the business's plan would make the trust the beneficiary. Is that
Not the beneficiary, but would assign control of the trust, sorry, of the business to the trust in the event you became incapacitated or died.
okay?
Yeah.
Okay,
What
gotcha.
kind is your business an LLC or a
It's
corporation?
S corp.
S corp. So your
Yeah.
shareholder agreement might already have provisions about what happens when you become incapacitated or die. And if it doesn't, then you probably want to go back to your business attorney and get that amended.
Okay. Thank you.
Yeah.
I also need to talk to you at some point. Thank you.
My
Thank
door
you.
is always open.
I appreciate these lunches a lot.
Oh,
Thanks.
great. Glad to have you. Okay, Cynthia, can investment accounts be put in trust or have beneficiaries? That answer is yes. Yes to both. Um, when we're talking about taxable accounts, so your straight brokerage accounts, um, those you can either put into your trust or you can make the trust the beneficiary or you can make somebody else the beneficiary. What we generally don't do is we don't put retirement accounts into the trust. Those have certain tax advantages. We generally want to see if we can make individuals the beneficiaries there. You can make the trust the beneficiaries of retirement accounts. We just have to walk you through some different options and consequences of that. Um, but generally speaking, if it's just a straight brokerage account, investment account, we put it into the trust, or if we're not doing a trust-based plan, we make sure there's beneficiaries. What they call a beneficiary for a brokerage account is a transfer on death designation. So, but it's the same concept. And if that didn't answer your question, Cynthia, give me a holler back. Levon's question, how to deal with property in more than one state? Well, there's a couple ways to pluck that chicken, as we say in the South. Um, Typically, you're looking at a trust-based plan recommendation where you create a trust in Florida, for example. You put your home that's you own in Florida in the trust, and then your North Carolina home, for example, we would deed into the trust. The only time that I don't recommend that way is if your other state. Remember when I was talking about that ladybird deed, that enhanced life estate deed could have a beneficiary attached to it? Again, there's pros and cons to that I would talk you through. But if that other state has something similar, often called a transfer on death deed in other states, we might be able to go that route with that out of state property. The majority of states do not have this option though, so it's not normal that I see that as an option. So typically you're looking at a trust-based plan because if you own, using my example, you own a home in Florida and you own a home in North Carolina, if you when you die and you either don't have a plan or you used a will-based plan, you're going to have a probate in Florida and you're going to have a probate in North Carolina. So you've doubled your probate there. That's why we generally suggest trusts when people own property in multiple states. All right, Dr. Joanne, how do we avoid the adult children from paying taxes on the home or money left over? Well, luckily for you, Florida has no estate tax, and the looks like the estate tax, the federal estate tax, is going to go away. And even if it doesn't, right now the threshold is $13 million per individual and 26 something million dollars for a married couple. So I have very few clients that are at that threshold where we have to do advanced tax strategies to avoid estate tax. So typically you're not going to see any taxes paid by your heirs when they inherit your property in Florida. The other nice thing about inheriting property, whether you do it through a ladybird deed or a trust or a will, is that your children, for example, or your beneficiaries inherit that property with, and be patient with me, I'm going to use some fancy lingo, with a step up in basis. And what that means, it's a tax phrase. Let's say that you bought your property for $100,000 back in 1980. And when you died, it was worth $1 million. So you've realized that $900,000 in gain. Well, if a person inherits the property, they inherit, at least right now, the way the law is, they inherit it with that step up in basis. So they would not pay taxes on that gain between 100,000 and $1 million when they went to sell the property. Now, if it was worth $1 million when you died and they kept it, and then it doubled to 2 million, they would pay taxes on that $1 million gain when they sold. That's why it's so important that parents don't deed properties to children, because when you gift properties versus inherit them, you don't get that same step up in basis. And it could be a tax nightmare to just gift a property to someone. Always get some tax advice if you're going to think about doing that. So Dr. Joanne, if that answered your question, great. If not, just hit me up again. Sandra Burdick, doesn't the bar require a succession plan? I'm assuming you're talking about the Florida bar, which regulates attorney conduct in Florida. The bar does not require a succession plan, but it does require that you have an inventory attorney. And all that inventory attorney does is inherit your files and then notifies your clients that you've died. They don't have to keep the file. They can get it out to somebody else. So that's sort of a succession plan, but that's one thing to think about when you're hiring an attorney is what does happen if they're not, they decide they don't want to practice anymore. What happens to their files? What happens to your relationship with them? Sherry. Oh
And
yeah.
Liz, sorry
Yes.
to butt in,
Yeah.
but that's
Yeah.
exactly what happened to us. Unfortunately, he was a
Yeah.
very young man that passed away,
Oh my
and he
gosh.
and he didn't have an inventory attorney, and we couldn't get the files. It was quite a heartache.
Oh my gosh. Well, heartache for everyone. My gosh.
Well, and who expects someone to die at 30?
Yeah. Yeah, absolutely. Well, I tell my clients all the time, we're all in line. We just don't know where we are in line, right? So, I'm sorry that happened to you. I know all the attorneys in my firm, we're each other's inventory attorney. So that's helpful. Um, I'm the second oldest in my firm, so that's something to look at too. Like what's their succession strategy? Do they have associates that are climbing up the ladder to be partners? If you want that long term, some people they just want to go get their will done and be done. Other people are looking for a relationship. So if you're looking for a relationship, that's kind of the stuff that you want to look for and ask about. All right, Sherry. Sherry is always, she makes me talk about money. Sherry, what's the average cost to create a trust? I don't know what the average cost to create a trust is. I know the range I charge to create a trust. And I'm going to give you the famous lawyer, it depends answer. And that just depends on how many, is it a joint trust? Is it an individual trust? Are we having to deal with minor children or special needs beneficiaries? Um, but I will tell you that for individuals, it starts at 2,500, and for married couples, it starts at 3,500, and it can go up from there depending on your complications. So that's give you the baseline. Those are my 2025 prices anyway. Oh, Nellie, happy belated birthday, Nellie. I'm interested in setting up a trust. Would this help the kids with having to pay capital gains on the condo that is willed to them? No, the capital gains wouldn't matter. Go back to that step up in basis I was talking to you about. So whether it's trust or will, they're going to inherit it with your step up in basis. So if they sell it right away, they're not going to pay any capital gains. At least fine print, big asterisk, right? As the law is right now. I cannot, I don't know what's going to happen with this administration, so I don't know where that's going to go. But as of right now, you don't pay on capital gains. I know that that was one of the running platforms during the previous election that we were going to do away with the inheriting with the step up in basis because the government's losing a lot of money, right? But as of right now, it wouldn't matter for capital gains purposes whether you did a trust or a will or a ladybird deed. So you might want to trust for other reasons, but that wouldn't be a reason to do it. All right, Anthony, I received an inherited IRA from my brother. Fidelity transferred this IRA to a newly created individual brokerage account in my name. I believe this should have been put into an inherited IRA in my name. What is the tax implication of this transaction by Fidelity? I can't answer that question. That's a little outside of my wheelhouse, Anthony. I would suggest talking with the tax professional for that. Also, maybe a lawyer regarding fiduciary malpractice. If you inherited the IRA, you should have inherited it should have been an inherited IRA, and you should have had that 10 years to withdraw. So that's all I can answer on that because I'm not a tax professional. I stay in my lane on the estate planning side and get that advice when I need it from a tax professional. All right. Another question. Lavon asked, what happens when a trust is created in Florida and the owner, I think owner lives in another state? Well, I can only do trusts for people that are residents of Florida. And so you can't have a Florida trust if you're not a Florida resident. So if you live in that other state, you would get a trust in that state. And then you could put Florida property into it if you had Florida property. But you can't be a Missouri resident, for example, and have me do your estate planning. Well, actually, you can because I'm licensed in Missouri. That was a very bad example. But New York, for example, you can't be a New York resident and have me do your estate planning. Okay, owner moved to another state. Okay, so thank you. All right, Lavon, that's a great question. So I have a client that then comes to me and I create a trust-based plan for them, right? So it's a pretty bucket, got all the bells and whistles on it. And for whatever reason, they decide to move to Ohio. I don't know why you do that, but they decided to move to Ohio. Does the trust work in Ohio? Yes. As long as your documents, and this works the converse, if they move from Iowa to Florida, as long as your documents were executed, meaning they were signed and witnessed in the manner in which that state requires, the documents will be honored in the gaining state. So in this case, Ohio. I always, 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 always recommend my clients, though, go talk to an estate planning lawyer there, wherever you're going to go, because there could be laws in place that you want to take advantage of. For example, when people move to Florida, we have constitutional homestead law that we want to ensure is enshrined in our documents. So that's one reason why we suggest when people move to Florida that they come see an estate planning attorney. But if they move from Ohio and things were done correctly, then I've probated many a will and administered many a trust that was done somewhere else. All right, next question. What's the process for setting up a succession file attorney? I'm not sure what that question is, Sherry. Could you elaborate either in the chat or come on? Are you still here, Sherry?
Yeah. You were talking earlier about if your current attorney dies, then you would have something in place called the file attorney, I believe is how it was put. So someone else would have access to all your files.
Yeah, that's something that the Florida bar requires the attorney to do. Okay. So in the database that I have with the Florida bar, which regulates the legal profession in Florida, I have named a person that if I die or disappear or become incapacitated, she then is charged with taking control of my files, finding someone else to manage them, letting the clients know. She can take the files if she wants. It ultimately is up to the client whether they want to go with that attorney or not. But it's just one way that you hope that it doesn't happen where a client has no idea that the attorney died and has now no access to their records, like what happened to Sandra. It's a little less necessary for me, as I very rarely keep original documents. When you work with me, you're going to take your original documents, and I have copies in my secure network. But if I died, you have all your stuff, and you don't have to come looking for it. So
Thank you. And
yeah,
I could just ask my current attorney, who is that person? She has
yeah, absolutely. And if they don't know or don't have one, you should probably get a new attorney.
Okay. Thank you.
I'll throw my hat in that ring.
Okay.
All right, Cynthia, is there a way to protect one's assets if they have to go into a nursing home? Meaning, can the money be dispersed to family prior in order to help with the cost of care? Great question. I actually do a whole lunch with Liz on Medicaid planning. There's not really a short answer to this question, but I'm gonna do the best I can. Do not disperse money. Gifting money can make you ineligible for Medicaid. If you have someone that either does need long-term care or you anticipate it happening in the next, 5, 10 years, talk to an elder law attorney who does Medicaid planning, because gifting it, dispersing it can have extreme negative consequences. But there are legal ways that we can transfer someone's assets so that they look poor on paper and can qualify for Medicaid, yet they haven't spent down or gifted all their assets. And these are legal ways that Medicaid approves. These are totally above board, but there are ways to do it. And it's something I do in my practice all the time, is helping clients protect the nest egg while still qualifying for long-term care. So um, I think the short answer to your question is, can the money be dispersed? Yes, but there is a 5-year look back. So if you disperse money, or let's say gift money to a family member, and now that person needs long-term care within that 5-year period, you're going to have a problem getting on Medicaid. If you've gifted the money and the person doesn't need Medicaid for 10 years, then you're golden. So, unfortunately, in my practice, I don't see a lot of proactive planning like that. I see more crisis planning where someone needs nursing home care, assisted living care imminently. And so we don't have time to mess with that 5-year look back. So then we have to look at other strategies to save the money, but get them on Medicaid. So, it's still a 5-year look back. Um, any other questions, or if I answered a question but you have a follow-up or want me to clarify, I would be happy to do so. All right. Well, while we wait to see if anyone else has any questions or commentary, thank you so much for spending your lunch with me today. We really enjoy having you. Appreciate it very much. We'll be back next month. I believe the topic is revocable trust, but don't hold me to that. I think that's what it is, though. Um, Anyway, if you would like to schedule a consultation with me, you can call the office or email Vicki at lizmoneymakerlaw.com. She'll put her email in the chat. And I offer complimentary consultations. Happy to talk to you about what we can do to make sure that your wealth is protected, your wishes are honored, and your integrity is upheld. Sandra, there was a takeaway at the top of the chat. And yeah, Nellie. We post them on our social media as well as on our website. All past, well, not all past, but the latest recordings we have been posting on the website, and that will go forward. So we didn't always record them, but we have recently. So, so I stand corrected. Thanks, Vicki. Next month is probate, the probate puzzle. What is it and how to avoid it? Way more fun than revocable trust because we'll also talk about revocable trust when we're talking about probate. So, all right, guys, thank you very, very much. Have a great rest of your day. And I think that's it. If you were just too shy to ask, I'll stick around till everyone buzzes off, at least for the next 5 minutes till 1 o'clock. And if you want to ask a question just more in private, just know that this does not mean we have an attorney-client relationship. So
thank you for all the information. Very helpful.
You're welcome. You're welcome. If you have questions, Vicki put her email in there. Happy to set up a consultation to go over any questions that you might have. Cynthia, no, I'm not licensed in Texas, so I don't know about Texas laws, unfortunately. I'm licensed in Georgia, Missouri, and Florida. All right. Thanks, everybody.